sentenced to pay a fine of 10 million on count number 1 and 6 million on count numbers 2, 3, 4, 5, and 6 respectively, making a total of 40 million. In default, the same to be covered by way of attachment and sale of the 8 accused persons. In addition, the 8 accused persons will compensate the National Youth Service the sum of 24 million 500,000 through the relevant paragraphs, including the account details can be provided by the prosecutor.
In entering into an agreement with the accused person regarding the sentence, the Director of Public Prosecutions took into account 1, that a plea agreement is a conviction. So the accused person is agreeing to a conviction and has been convicted. Secondly, the Director of Public Prosecution has taken into account the fact that the accused person has consented to cooperate with the Director of Public Prosecutions and the investigations and the investigating officers in pursuing other matters in relation to cooperate with the prosecution and the investigations in other matters pursuant to this subject matter, that is NYS matters. The Director of Public Prosecutions has also taken into account the fact that the accused person has agreed to restitute back to the National Youth Service 24 million. In fact, it is 24,500,000.
Yes.
Consequently, the Director of Public Prosecution has agreed with the accused person that he enters a plea in 6 counts. The maximum under those sections, 16(2), on each count is 10 million. So if we went for the maximum sentence, which we are pursuing, the 6 counts, each count, the maximum in the statute is 10 million. We have agreed that the accused person shall pay 6.6 million on each count. That is a total fine of 40 million. And then 24,500 will be restituted back to the National Youth Service. 24,500,000 will be 6.6 million per count. Total is 40 million they will pay. And 24,500,000 will be paid back to the National Youth Service. We would have wanted or loved that they paid the maximum of 10 million per count. But taking into account that they pleaded guilty at the beginning of these proceedings, they have saved the time of the court and the time of the prosecution, and the investigators too. And secondly, the 8th accused person is a juridical person, that is a non-human legal person who cannot be sent to prison. So at the end of the day, the sentence will still be a monetary fine. Acknowledging the discretion of the court, it is our humble submission that we acted in the public interest. We upheld the rule of law. And finally, in the interest of justice and the interest of the victim who has been restituted.
Public interest, rule of law.
And in the interest, and we have also taken into account the rights of the victim. And at the end of the day, it is our view that justice has not only been done, but been seen to be done. We shall be grateful if the plea agreement is accepted in totality and that the rights of the victims is also upheld. Thank you. One more point that I didn't mention, Your Honor. We also took into account that Family Bank cooperated with the regulator, who is the Central Bank of Kenya, and they demonstrated that they have put in mechanisms to deter repetition of such offences, and the same is also captured in the plea agreement. We took it in, it's in the plea agreement.
It is in the plea agreement.
So you are giving me the entire...
I'm supposed to give you under section 137H, I am supposed to give you the factual basis of the plea.
So you were saying that Family Bank did what?
I mean, they cooperated with the regulator.
Yes.
And the regulator confirmed that they put in mechanisms to prevent further occurrences or infractions. So for record purposes, we will draw count 7, 8, and 9 against the 8th accused person.
Yes. Your Honor, I adopt what has fallen from the lips of my learned friend in explaining how the pre-bargaining agreement came to be. I wish, however, to emphasize 3 matters. One, right from the beginning, Your Honor, we got in touch with the DPP's office when we got appointed with Madam and Mr. Miller with a view to compromising on the charges and the right of the facts that were disclosed by the investigation. We have cooperated all along with the investigators and the office of the DPP. Number 2, Your Honor, upon the weaknesses being demonstrated that led to failure to report in accordance with the law, we sought the assistance of the regulator and have instituted measures to make sure that this kind of failure cannot and will not occur in the future. there is no better person to say that than my learned friend who confirms that the regulator indeed has ascertained that has been done. Number 3, Your Honor, we think justice, taking into account all considerations, has been done in this matter. The regulator has vindicated itself by showing that there was something amiss in failure to timely report the transactions that were suspicious. Yeah, has vindicated its position in demonstrating that there was some failure in reporting some suspicious transactions. And by pleading to the charges, the rule of law, particularly in regard to prosecution of offenders, has been acknowledged. But most importantly, like the prosecutor has informed the court, the victim has been compensated. Accordingly, Your Honor, it's our firm belief that the plea bargaining agreement is an expression of justice having been done in all the circumstances pertaining to this matter. It is our humble request that the plea bargaining agreement be adopted as a note of the court in its entirety, and if that is done, Your Honor, we undertake to pay the fines forthwith. That's all we wish to say, Your Honor. Thank you for your attention.
Is John Kingori Moshiri, Honor. Perhaps before, Your Honor, you inquire of him, I would like to give a copy of the resolution passed by the Board of Directors of the aid accused, appointing him the agent of the bank for purpose of taking a plea. The second document, Your Honor, is the letter appointing him upon the resolution being made by the directors of the bank. And finally, Your Honor, a certified copy of the resolution by the directors of the bank approving and endorsing the agreement between the DPP and the bank. I think I've given copies of the three documents. Perhaps, Your Honor, before you ask him any questions or make any inquiries, I can confirm from him whether he is aware of these documents, and so that he can formally produce them.
You have the originals?
We have the originals, yes, we can give the originals. But we have a certified copy by the chairman and the corporation secretary. Yes.
Where the certified copy is now, or is it certified?
I have the certified copy here. They are the original he has them. Your name is Mr. Mushiri. And you are the jury appointed agent of Family Bank for purpose. Your full name. And you are the jury appointed agent by the bank through a resolution of the board to come and represent the bank in this proceeding. And indeed, you have been authorized to take plea in the matter.
Yes,
Have you read the resolution of the Board of Directors passed on the 17th of December 2018 approving the plea agreement between the DPP and the bank?
yes,
And you agree with what the board has done? And you wish to produce the three documents?
yes,
The original resolution appointing you the agent,
yes,
the formal letter written to you by the managing director, and the resolution by the board of 17th of December 2018. That's all you want.
The plea agreement has been recorded, is documented. It was shared with the legal representative of the eighth accused person. And both parties are in agreement. I therefore humbly request the court to record the plea, subject to recording the competence of the person who will represent the eighth accused person who is an entity. The factual basis and the facts are contained in the plea agreement, which we shared with the court, and I have the original. I believe the next step is the court to find out the competence of the person entering the plea on behalf of the eighth accused person who is an entity, and thereafter we shall not address the court on the conviction and sentence. Much obliged.
Also that we have been explained to, the court accepts the plea agreement. Now we will move to taking plea. So, John, Family Bank Limited, represented by John Kingori, you are charged with 8 counts. I am required to respond to each of the counts. Count number 1, that your failure to report suspicion regarding the proceeds of crime, under Section 5 as read in Section 34 and 16 of the Proceeds of Crime and Anti-Money Laundering Act number 9 of 2009, that you, Family Bank Limited, between 22nd December 2014 and 19th May 2015, at Family Bank Limited, KTDF Branch, Nairobi, within Nairobi County, being a reporting institution, failed to comply with the reporting obligations, which were failing to report unusual transactions relating to account number 06500007847 belonging to Josephine Kabura Irungu, carrying on business under the business name of Post Concrete Technologies, held at Family Bank Limited, KTDA Branch, Nairobi. I now call upon you to admit or to deny the truth of that charge. What do you say? Business under the business name of Form Home Builders, held at Family Bank Limited, KTDF Bank, Nairobi. True or not true? Count number 4, failure to file reports of cash transactions equivalent to or exceeding $10,000 US, contrary to Section 44.6, as read with 16.2 of the Proceeds of Crime and Anti-Money Laundering Act number 9 of 2009, that between 22nd December 2014 and 19th May 2015 at Family Bank Limited, KTDF Branch, Nairobi, within Nairobi County, being a reporting institution, you failed to comply with the reporting obligations by failing to report unusual transactions relating to account number 065 followed by 507847 belonging to Josephine Kabura Irungu, held at Family Bank Limited, KTDF Branch, Nairobi. I call upon you to admit or deny the truth. 507849 belonging to Josephine Kabura Irungu, held at Family Bank Limited, KTDF Branch. Is it true or not?
Oh, yeah.
Your guilt is entered on the 6th count. funds are quite lengthy. They are included in this plea agreement?
Yes, they are. And just